SJC 13379, Commonwealth v. Michael J. McNeil.
Okay, Attorney DePalma.
Yes, good morning. May it please the court. My name is Valerie DePalma, and I represent the defendant appellant Michael McNeil. Mr. McNeil was unlawfully adjudicated a third offender under the shoplifting statute. Under that statute, a person convicted of a third or subsequent offense is subject to either a fine up to 2 years in jail or both. What is at issue in this appeal is the meaning of the word offense as it is used in this context. The statute does not define the word offense, and in these circumstances, the common law definition fills in unless it is contrary to the statute's purpose. This court recently in Wallace W., 2019 case, discussed offense in a very different context. It was used with respect to offenses that are excluded from the juvenile court's jurisdiction, but its discussion of offense in that context is helpful, particularly its statement that offense as used in sentencing statutes is typically synonymous with conviction or adjudication, citing explicitly the shoplifting statute. So I believe it's fair, even though that statement isn't directly part of its holding, I think it's a fair and very recent pronouncement by this court.
Can we look at, I think the only case on this is that Simon's case, Judge Spina's case?
Yes, yes.
So he lays out the common law roots as you talk about.
Yes.
And basically says that, as I read it, he said the purpose of a guilty foul would be to suspend a sentence.
Yes.
It was in lieu of before they had probation, correct? So a judge could adjudicate someone guilty, but I'm not going to suspend you, keep your nose clean, and we'll just keep it in abeyance.
Yes,
that's why we're here, right? That's what a guilty file does?
Yes, it's active proceedings are suspended indefinitely until either party can seek to remove it.
And that was a problem that Justice Spina indicated in Simon's, because people wouldn't do anything with them; they would just leave them hanging.
Right, and you know, and interestingly, in doing the research for this, because you think, oh, it's got to be an easy answer, and there never is. It's always like, and the courts that have wrestled with this question are the federal courts,
right?
Because they're constantly, being asked.
And that goes against what the federal courts have done.
Well, not one. Actually, it's a district court case called Carey. It's cited in my brief, and it's the one case I brought because I like it is it was very well reasoned. It is 716 F sub second 56. It's a Maine.
But isn't that interpreting the federal?
ACA.
It's because I read it too. It's Judge Woodlock, and it's very well reasoned, but it really is interpreting federal language, not the meaning of offense or adjudication.
True, but under the ACA, they have to follow Massachusetts. It's whether Massachusetts designates the offense as a conviction. So then he had to go at the latter part of the opinion discuss, well, what have Massachusetts courts said? And as Justice Graviano pointed out.
And what I'm struggling with is the Simon's logic, where it is an adjudication of guilt. That's what troubles me as to whether or not that's an offense, because it's an adjudication that you committed the offense.
Right.
You committed the crime alleged.
Yeah, I kept trying to think of it as kind of the flip of a quaff, but it doesn't really work.
I did the same thing. I was trying to think because it's before it existed the common law. And a quaff is different because there's no adjudication.
Right, you have just sort
of
a
dismissal.
Right.
Later on.
And you do have, here you have the entry of a guilty there's an actual
so I
entry.
think it's actually more.
So there is a finding of guilt. either after a plea or a guilty verdict, but we have no sentence. Whereas a quaff, there is the admission, but it's never entered, which is, of course, the entry is critical, I think, for our purposes. And also a potential for dismissal, but also a potential for, a violation, and then, it could ripen into something.
But then you're found guilty if
Right,
right
and then it becomes
thereafter.
right. But until either that period it's open, until something happens, it's still not an entry and not a sentence. It's open. So they're not quite.
I'm
Yes.
sort of
ahead, I'm sorry.
I'm sort of jumping ahead here. I realize it, but I sort of want to cut to the issue. So it seems clear that Chapter 266 are using offense and conviction. It's interchangeable. On the other hand, there is no disposition in a guilty file.
Right.
And we have cases that you could look at in both directions. And so skipping ahead, why isn't the resolution here the rule entity?
Because, as I mentioned, there was, the cases can basically be grouped into two. One is conviction triggering a disqualification, forfeiture, or other such, a penalty of sometimes civil. Typically, those cases interpret conviction to mean that they must imply, the conviction implies a judgment, i.e. A guilty finding plus a imposition of a sentence. And then there's other cases that have interpreted conviction in the context of other statutes where the word conviction is really describing a stage of the proceeding. And in those cases, conviction has been interpreted to mean just a finding of guilt. So where my argument, and the amicus also that was submitted, argues that this is obviously a statute that triggers a penalty, a sentencing enhancement, and that from that point of view, it should follow the cases that interpret conviction to mean implying a judgment. And the other reason is the rule of lenity, which is...
Haven't you already gotten your lenity? You got the lenity the first time around when they filed the guilt. I mean, it's a little difficult to argue, oh, I gave you a break so that you would behave, but if you misbehave, I'm going to reimpose that. And then say, well, the rule of lenity now applies on the second one. You gave me a break the first time. You shouldn't have. Now I'm going to oppose it. I find that a double lenity. I'm not sure I've ever seen anything like that before.
Well, I think it's a rule of statutory construction. And as the court knows, it's implied when a statute is ambiguous. And because it's a criminal statute, the defendant gets the benefit of the ambiguity. And yes, my client had, he received a guilty filed in his past, and the question is, can that be used to enhance his sentence pursuant to the repeat offenders of the shoplifting statute? And I would argue that this is really, if the prosecution had wanted him to be sentenced as a third offender, they could have removed the filing, imposed, and for a second, it's still a fine, and turn this into a conviction if they had wanted to before this proceeding, or, I think...
Have to be before the crime. But what about...
Well, he'd have to be convicted before. I think they do follow sequentially.
Issues. So what about the issue, though, that isn't it just obvious in the Chapter 266 that offense means conviction?
I think Yeah, I think it means conviction, and then the question, is it conviction meaning plus sentence, or is it conviction meaning just entry of a guilty finding?
Well, if it's a conviction, why wouldn't it count as a predicate?
Well, I think if it's a conviction, if it's a conviction in the sense of a guilty finding plus a sentence, then it should count. But and as footnote 2 in Simmons says, Justice Spina made, I think the footnote serves as a clarification that the cases referred to guilty filings as convictions, and he was sort of making the point that they're not. They're something different. Because convictions, as he says,
Isn't he
imply
saying, I thought he was saying, it's a misnomer to say they're,
convictions.
well, it's a little unclear what he's saying on that. I thought he was making the opposite point, that we
Really?
shouldn't call it, well, where's the exact language he uses? I'm trying to.
It's in footnote 2, and he says, "We note that our jurisprudence commonly has referred to this practice as placing convictions on file. It is well established that a judgment of conviction does not enter unless a sentence is imposed." So meaning, because a guilty filed means there's no sentence imposed.
Then he goes on to say, so to place a conviction on file is internally contradictory, suggesting, I thought he was making the opposite point, that, okay, it is clearly a conviction, so we shouldn't use this, I don't know.
I thought he meant, you can't, if you have a conviction, you can't file it.
I thought he was just talking about the nomenclature. Was
Yes,
off-
and that,
was off.
multiple readings are and then although this is an error, we will.
Doesn't make me feel good because he's a better writer than me.
Always the footnote.
Words are always, ambiguity cannot be
Always the
avoided.
dicta.
Yeah.
It's always the dicta.
So I think, at least in my view, this, and again, this is also dicta, but it's not obiter dicta, I guess, it would be that, it wasn't necessary to the case's holding, but it certainly wasn't a non sequitur or just a throwaway comment. It was an important statement of the law. And since this time, there hasn't been any other cases that at least directly have confronted this issue. And so, does any have any other questions?
I guess I only point out the obvious. This may be the Pyrrhic of all Pyrrhic victories, because either way, if you come out and say that it's a conviction without a sentence and it's not triggering, or the rule of lenity, this will be the last defendant to get the rule of this lenity.
Yeah.
And that would be an important thing in community courts where there are a whole lot of good people who have violated a criminal statute, that this particular device has been used for a long time.
Well, I think I don't think it will. Someone did raise the specter of the destruction of the guilty filed as a possibility, as a sentencing option. I don't think judges will not use it. I think it's still a useful.
Don't the prosecutors have to agree?
Yes.
That's the problem.
Right.
I think they'll start objecting.
Well, if it's not going to serve as a predicate, particularly in these kinds of crimes, these kind of quality of life crimes. These are the kind of crimes that drive Walgreens out of neighborhoods.
Well, I for sure it's. For sure this decision will be of consequence, not just to, local courts, but to federal courts and immigration and.
Which it's a hard question. That's why it was reported
Yeah.
appropriately.
Yeah,
so.
no, it is. It's an important question. But I also think that, yes, there will be some
Could I-
reconfiguring.
Can I ask you one sort of technical question about that footnote for a second? When Justice Spina writes, it is well established that a judgment of conviction does not enter. Is he drawing a distinction, judgment of conviction as opposed to, offense or conviction? Because a judgment's the, finality.
You're right, yeah, my sense is a judgment is
But
the
is he saying-
conviction and sentence. Once the sentence is imposed, it
Right,
then
but the-
becomes a
But this
judgment.
person's clearly been convicted, but they haven't been sentenced. But is he drawing a distinction there between a judgment of conviction, meaning that sort of the judgment's issued, so we've gone one step further than a guilty filed?
Yeah, yes, we've imposed sentence, and, well, it becomes final and appealable.
Well, you see, but I'm wondering if he's choosing his words particularly carefully there, drawing a distinction between a conviction and a judgment of conviction.
Well, that will be something we'll have to. Thank you.
Okay, thank you very much, and my client and I ask that you vacate the finding or the adjudication as a third offender and remand to the district court.
Okay, thank you.
Thank you.
Attorney Moriarty.
Good morning. May it please the court, Marina Moriarty on behalf of the Commonwealth. Your Honors, the Commonwealth urges this court to hold that a guilty file constitutes a prior offense for the purposes of the shoplifting statute. The Commonwealth contends that the legislature was intentional in its use of the word offense in amending the 2018 shoplifting statute and deliberately chose the word offense as opposed to conviction, which suggests that there has been both a finding or a finding of guilt and a sentence imposed, and a conviction is something upon which a defendant can appeal. Without a sentence, the case law has pretty continuously held that there is no appeal. The Commonwealth suggests that this holding would be consistent with Wallace W., although Wallace W. Had some dicta in it that suggested that offense is synonymous with conviction.
Wallace W., the issue was whether a probable cause finding was going to be an offense or a conviction. And Wallace W. points out that we use offense and conviction interchangeably in these statutes, and it's not that clear. So I'm not sure what was summarily done in Wallace W., as you write. Actually, it was pretty carefully done. So what's your point?
My point, Your Honor, was simply that it wasn't the issue in the case. It was raising that fact that the shoplifting statute did have the word offense in it, just like the word disorderly conduct has the word offense in it, and it's the same for disorderly conduct, that a second offense, disorderly conduct, now subjects a person to possible imprisonment where the first offense is simply a fine. So my point, Your Honor, was simply that it was not the holding in the case. It was pointing out that offense is used in this statute, and I would suggest that the holding in Wallace W., where this court held that an offense was something more than a finding of probable cause, but something less than an appealable conviction, was an offense within the meaning of the juvenile justice statute, which was also part of the 2018 criminal justice reform. I would suggest that the Commonwealth's interpretation of the statute is also consistent with the definition used in the 2018 criminal justice reform, although in a different context. Offense is used in the context of expungement, where it simply says an offense is a violation of a criminal law for which a person has been charged and has made a criminal court appearance or juvenile court appearance for which there has been a disposition and a record. Here, pursuant to Mass Rule of Criminal Procedure 28E, there not only is a record, but in order for a guilty file to enter, there has to be both the consent of both parties and a finding by the judge of guilt. I would also suggest that this interpretation is consistent with the intent of the legislature to offer leniency for both the first and the second offense of shoplifting, but at some point, there needs to be some actionable deterrent on the part of the Commonwealth to prevent individuals who persist in serial shoplifting for a variety of reasons to make them appear before the court and amenable to rehabilitation. Finally, I would suggest that the Commonwealth's interpretation is consistent with the plain words that the legislature used. The legislature did not use the word conviction. They clearly know how to use the word conviction. They use the word conviction in the OUI statute, in the common and notorious thieves.
But the legislation, offense and conviction are often used sort of in an offhand way, aren't they? We've got a lot of statutes like that. It's not like there's a clear line in the case law between an offense and a conviction, right?
Well, I think that's why we're here, unfortunately, and I do think that this court has said that words matter. And so where in the where the common and notorious thief, section 266, section 40, writes whoever having been convicted upon indictment of larceny and goes on, I do think that the fact that they did not use conviction should be at least considered by this court as something less than requiring a conviction to prove a first and second offense larceny. And I suggest that a guilty file is that kind of middle ground.
How do you deal with the rule of lenity?
Well, I do think that it's consistent with the word offense. It's consistent with the individual has been put on notice. They have made an admission, a judge in open court. They have been made aware of the guilty finding. They had to consent to it. And so I think in the first and second instance, they were granted the lenity here. I do think that the legislature intended there to be some mechanism to prevent and punish shoplifters. I do think that preventing guilty filings from entering, if this court were to hold that guilty files do not count as a predicate offense, I do think that would significantly deter district court prosecutors from entering into guilty files. In my experience and in speaking with district court prosecutors, these kinds of filings are very often used in these kinds of low-level misdemeanor cases where individuals are not amenable for whatever reason to pretrial probation or to...
Do you think there's any ambiguity in the shoplifting statute with using the word offense?
I don't think so. I think...
Do you think it's unambiguous that offense includes guilty filed?
Yes, I do. And I think
So
guilty...
it's crystal clear in your mind that that's true. Because the rule of lenity is not whether or not he got a break the first time. It's a rule of construction, as your opposing counsel says.
It's a rule of statutory interpretation,
Right.
I understand, but I do think that when a guilty file, just by the words of guilty file, suggests that a person has been put on notice that they have committed an offense of shoplifting in the
Right,
past.
and that in your argument is that is crystal clear.
Yes.
Okay.
These kinds of guilty file cases are often not amenable to pretrial probation, are often not amenable to quaffs because individuals do not want to be subject to probation for any period of time. I would also suggest that there's no other disposition other than guilty fine. If guilty file is taken off the table for these first and second offenses, you can't offer guilty probation. The only disposition would be either a dismissal or a guilty and some sort of fine associated with that, which I would suggest isn't necessarily effectuating the intent of the legislature with respect to offering leniency on first and second offense shoplifting. If there are no further questions, I'm happy to rest of my brief.